Welcome back to the first week of lectures of the course Citizenship and U.S. Immigration. This week we are considering citizenship, and today we look at the status of persons born in U.S. territories and possessions. Before we move into this subject, I want to pick up where we left off in the last lecture. We were talking about the status of Native Americans, and we said that their status as citizens of the United States is not based upon the 14th Amendment, but rather is by statute. I wanted to show you this image of President Calvin Coolidge meeting with 4 members of the Osage Nation just after the signing of the 1924 Indian Citizenship Act. This act awarded United States citizenship to all Native Americans living within the United States, including those living on tribal reservations. I also want to go back to the case that we discussed, Elk versus Wilkins, decided in 1884 by the United States Supreme Court. And this is a slide that I've shown you before, but it's good to remind ourselves of the 14th Amendment's particular language on subject to the jurisdiction thereof, because this will be key to the status of persons born and living in U.S. territories and possessions. So to remind you of some of the most important language from that decision, members of and owing immediate allegiance to one of the Indian tribes, although in a geographical sense born in the United States, are no more born in the United States and subject to the jurisdiction thereof within the meaning of the first section of the 14th Amendment than the children of subjects of any foreign government born within the domain of that government, or the children born within the United States of ambassadors or other public ministers of foreign nations. This language and this case established that Native Americans living on tribal reservations did not become United States citizens at birth. So it was the 1924 Indian Citizenship Act that accorded them that status. As a dependent sovereign, only the United States Congress may legislate in tribal reservation areas, not states. So tribal reservations are not within a state in a political sense. This is a concept of collective naturalization, by statute or treaty, awarding citizenship all at once to an entire group of people. It's been a very important element of citizenship in our history. I'd like to show you a map and discuss what this represents. This is a map of U.S. territorial acquisitions over a relatively long period of time, beginning with the Louisiana Purchase in 1803, through the annexation of Texas in 1845, and the Gadsden Purchase from Mexico in 1853. In each instance, when the United States assumed sovereignty over all of these territories, there were many persons of various nationalities already living there. Many had lived there for some time. The treaties awarded United States citizenship to all persons in these territories who chose to remain, or at least to free white persons in the instance of the Louisiana Purchase. The choice was with the resident. If one did not wish to become a United States citizen, renouncing citizenship of the former country, one would simply leave the area, but if you stayed, the presumption was that you intended to and would become a United States citizen. So these various territorial acquisitions, again, the Mexican Cession in 1848, Gadsden Purchase, Texas annexation, those are from Spain and from Mexico. The Louisiana Purchase was from France, but there were many persons of Spanish descent living there. One issue that arose, the treaties also protected existing property rights, at least in theory. So those persons who chose to stay could keep their property and become U.S. citizens at the same time. So this map represents the acquisition of territory into the United States, the contiguous United States as we know it today. The topic that we are turning to, though, is U.S. territories and possessions. The United States has a number of these: American Samoa, Guam, the Northern Mariana Islands, Puerto Rico, the U.S. Virgin Islands, and a group of islands known as simply the Minor Outlying Islands. There are 9 of these, most of which are not populated. So for these territories and possessions, we are talking about outside of the 50 states, except in certain cases with respect to U.S. territories. Birthright citizenship is only statutorily recognized with regard to persons born in these territories. We will unpack what that means in the course of this lecture. So the question that we're interested in now, which persons born in a U.S. territory are citizens of the United States and which are nationals, and what is the difference? I'm referring you here to the Immigration and Nationality Act for more details. That's the reference INA, and sections 302 to 308, which are readily available on the web, are the appropriate sections for you to review for that question. For U.S. territories, including Puerto Rico, statutes of Congress govern the status of persons born there. So, for example, if you're born in Puerto Rico, you are a U.S. citizen, but it's not because of the 14th Amendment, but because Congress has awarded it. Congress can change its mind on this without amending the Constitution unless Puerto Rico were to become a U.S. state. What is a U.S. national? A U.S. national receives a United States passport with notice that the person is not a United States citizen. It applies to a few of the smaller territories and possessions of the United States, but not to Puerto Rico, as we will see later. U.S. nationals can live and work in the United States at their pleasure. They can also apply for citizenship and have a faster track to naturalization. All U.S. citizens are U.S. nationals with respect to international law, but the reverse is not always true. American Samoa and some of those outlying islands that we discussed, their citizens are U.S. nationals rather than U.S. citizens. Over the course of the 20th century, Congress changed these statutes a number of times. So to be certain of one's status, if you were born in the territories, you would need to check the statute that was in effect at the time you were born. Congress has amended these sections frequently, and they are usually not retroactive. I want to discuss a new set of Supreme Court cases that established extremely important precedent with respect to the status of territories and possessions. These are known as the Insular Cases. They are a series of U.S. Supreme Court cases decided in the early 20th century. Essentially, this series of cases established that full constitutional rights do not automatically extend to all areas simply because they are under American control. The Constitution does not follow the flag, in other words. Territories and possessions instead must be incorporated into the United States for the full range of constitutional rights to apply. An example of incorporation, of course, is statehood, and our most recent incorporation of territories include Hawaii and Alaska. The Insular Cases also affirmed the point that Congress determines the rights, responsibilities, and the citizenship or nationality for all persons in territories and possessions of the United States. Let's take a closer look at Puerto Rico and U.S. citizenship as an example here. It's our most populated territory, and we hear about the possibility of citizenship for Puerto Rico from time to time. But let's look at the current status. In 1900, Congress replaced the governing military regime in Puerto Rico with a civil form of government. Section 7 of this act created a Puerto Rican citizenship for the residents, quote, born in Puerto Rico and therefore subject to its jurisdiction. The Puerto Rican citizenship replaced the Spanish citizenship that Puerto Ricans held at the time of the American invasion in 1898. So the United States is providing for citizenship of Puerto Ricans following the war with Spain over Puerto Rico. In 1917, Congress granted collective United States citizenship to Puerto Ricans without rescinding their Puerto Rican citizenship. So in some ways similar to how Native Americans are treated within the United States, they are both citizens of Puerto Rico and citizens of the United States by statute, and this has been true since 1917. And here, the Insular Cases become important again. In one of these cases, in 1922, the United States Supreme Court ruled that the full protection and rights of the United States Constitution do not apply to residents of Puerto Rico until they come to reside in one of the now 50 U.S. states. So what does this mean for Puerto Rican citizenship today? Constitutionally, Puerto Rico is subject to the Congress's plenary powers under the Territorial Clause of Article 4, Section 3 of the U.S. Constitution. We're going to be discussing Congress's plenary powers in this and in areas of immigration in future lectures. It also means that U.S. federal law applies to Puerto Rico, even though Puerto Rico is not a state of the American Union, and their residents have no voting representation in the U.S. Congress. On the other hand, Puerto Ricans may freely travel to and reside in the United States, and if they do so, if they establish residency, they possess the full constitutional rights, including the right to vote, of any other American citizen. Finally, let's look at another issue with respect to citizenship in the United States, and that's a term used in the Constitution, natural-born citizen, to describe eligibility for President of the United States. This appears in Article 2 of the United States Constitution, which states that the President must be a natural-born citizen. The Constitution itself does not define what a natural-born citizen is. Moreover, the United States Supreme Court has not had the opportunity to define natural-born citizen because no one has challenged a candidate on this basis in any case that has reached the United States Supreme Court. Some scholars argue that natural-born citizen must mean birth within one of the 50 states. But the better and more accepted view is that natural-born citizen simply means you are automatically a U.S. citizen at birth. This can occur when you're born abroad to U.S. citizen parents. If the law in place at the time you were born automatically granted you citizenship in the United States based upon the citizenship of your parents, you are considered a natural-born citizen, and this is consistent with the understanding of the framers of the Constitution. In fact, we have had many candidates for president who were born abroad to U.S. citizen parents. One example is John McCain. He was born in the Panama Canal Zone, then under U.S. control. His parents were United States citizens, and that was sufficient to award him citizenship at birth, making him a natural-born citizen. Most recently, of course, the issue has come up with respect to President Barack Obama. President Obama was born in Hawaii in 1961. President Obama produced a birth certificate proving his birth in Hawaii after it had become a state, and therefore President Obama is a citizen of the United States based upon the 14th Amendment to the United States Constitution. Furthermore, he is considered a natural-born citizen and would be so even if Hawaii had still been a territory at that point. In our next lecture, we'll consider the rights and responsibilities of United States citizens.
The preceding program is copyrighted by Emory University.